have very few virtues. So virtually introducing a society of people with no vices and few virtues. But my lord, in these qualifications and disqualifications, these very long list, there is a connection. And the connection is that you cannot read Article 62 without looking at Article 63. And even earlier, you could not read Article 62 and 63 without being conscious of the rights of citizens under Article 17 of the Constitution. This court has always been mindful not to disenfranchise people, that the right of people to form and join political parties is there, and a person has a right to contest elections. 62 and 63 both make inroads to an extent under that fundamental right. The inroads were sensible inroads when it came to the original 1973 Constitution, that we will not allow an insane person to be a member of the Parliament, that we will not allow an undischarged insolvent to be a member of Parliament, we will not allow a person who is not the citizen of Pakistan or is the citizen of another country to be a member of Parliament, that we require that persons should be at least 25 or 30 years of age, being National Assembly or Senate respectively, to be members of Parliament. And that none of those make an inroad into Article 17 of the Constitution.
So why are we interpreting it in this manner then? And then something has also been said that ordinary legislation is not a substitute for a constitutional amendment. Okay, you bring in a constitutional amendment, we strike it down. So our wisdom is paramount. So we can do whatever we want to, not guided by anything other than our own vague ideas of morality.
My lord, and that is the submission that two things you will not find. You will not find a judgment from the common law jurisdiction where by a declaration of the court, because this is not a declaration of Parliament, my lord, Article 63. And
you concede that this is no disrespect to anyone, will you concede that the parliamentarians in Pakistan are the best in the world? Are the best in the world? Surely not. Don't be hesitant. There's no disrespect to anybody.
No.
Does any other country, a single country in the world, have this test for parliamentarians?
My lord, not that I am aware of. Not the US Constitution.
So if we have this test and we don't have the best parliamentarians in the world, that means this is not even a workable law, if at all anything else. It's just words on a piece of paper which I can use for my personal projects, I would say. Tomorrow you are honest, you can be declared dishonest, out, in, it's up to me. I can just write some few words of English language and that's that.
To give an immediate example, the US Supreme Court has a similar requirement: citizen, age.
Those are, you can physically,
yes. Like we had in the 73 Constitution. Even when the US Congress sought to introduce new qualifications of this kind at a particular period of time, in Powell versus McCormick, the US Supreme Court struck it down. They said no. The Constitution has given a list of qualifications. Congress cannot add to that list of qualifications. That's where we stop. So the courts in other places have gone the other way. They've said, here is
speaking for myself, we have to, expounding the Constitution, we have to rely on the tools of interpretation.
My lord, yes.
I look at the Constitution post 18th Amendment. For me, the dictator argument is out of the window because it is the 18th Amendment passed by the Parliament. So I need to give it a very serious thought in interpreting the Constitution. So every word to me is important. I could just disregard all the words and say this is not the Constitution. That cannot happen, even though I might disagree with the wording of it, but some meaning has to be attributed to it. I find the declaration firstly making no sense, but I have to give it a meaning because I can't throw it out of the Constitution. I don't have the jurisdiction to do that. So having said that, you were at that moment explaining that the court of law could have criminal and civil both. Could you just resume from there and explain?
A court, can you also attend to a side query with what my lord has just observed? My lord is, with the greatest respect, assuming that there will be redundancy to the Constitution. I would reframe it. There would be redundancy to the interpretation of the Constitution by this court, which is not quite the same thing. The Constitution does not say that you stand disqualified. We say you stand disqualified.
My lord,
If the Constitution had simply said so, end of story, fine, that argument would be. But it is how we interpreted the Constitution has said so. I don't know if that's a valid point or not.
May I just counsel that mediate a safer course for myself by saying, by saying.
No, please, we never mind anything being said here.
No, my lord, because
you see, we bounce ideas, our thinking clarifies.
Take the hard response.
My lord,
Be as critical as you want.
my lord, the safer course which I suggest for myself is that when your lordship looks at the Constitution, whether your lordship looks at it, my lord, my lord the Chief Justice is looking at it, or my lord, your lordship Sayyid Mansur Ali Shah Sahab is looking at it, there is no redundancy. Redundancy is created by Samiullah Baloch. If your lordships read the Constitution the way Samiullah Baloch reads it, there is redundancy. If your lordship reads the Constitution, the legislature intended it after the 18th Amendment, there is no redundancy. Because if a court of law includes a court of criminal jurisdiction, then it immediately takes your lordship to the provisions of Article 63, 1G and H, and there the limits are specified. Their lordships then make a further distinction, and that's again Samiullah Baloch, that a person who has been convicted has then paid his debt to society, forever suffers the odium of being a convicted criminal, and therefore he is in a different league than from a person who suffers a civil liability. Parliament doesn't make that distinction. The court does. It is the interpretation of the court which is making the Constitution redundant. My lord, that logic also does not hold. Why it does not hold? My lord, in criminal law, and my knowledge of criminal law is very, very peripheral, and your lordship will excuse me for that, but I make a distinction always between conviction and sentence. A person serves out a sentence. A person never serves out a conviction. The conviction remains on his record forever and ever. If he has served even till the rising of the court.
Mahdub Ali Khan, that's another matter which is pending adjudication in this court. I am of the view, and others of a different view, and I had requested for a larger bench to be constituted, and I may be failing in my duties not to have done so myself, but so much has been happening, we're working morning to night, was that in a murder case, 345 allows compounding of an offense. There are two views in this court prevailing. One view is it brings the sentence part to an end. It does not efface the conviction. The other view is it effaces the conviction and the sentence both. So even if we apply that debt to society part, suppose a person commits murder and next day secures a settlement with the legal heirs, where is the debt to society has been paid? It hasn't been paid. He will file a nomination papers. Have you been convicted of an offense? Answer will be no. If that interpretation of the Constitution is followed, which says that it effaces the conviction and the sentence, he will honestly answer no. Whereas if the interpretation which I have favor holds, he will say yes. Sentence part would be a different part. So even though he didn't pay debt to society, did not serve one day in jail, he still can contest election in that scenario. So this debt to society argument, I also find a bit fallacious.
But that's the...
I guess let's wait for a larger bench on that question, because that will take us yet to another argument altogether.
I think what we don't remember of that. For the debt to society argument...
It's already there, my opinion, written.
Debt to society argument in the Samiullah Baloch case, when your lordship looks at 63...
So, Mr. Makhdoom, I mean, taking up that argument that you said, court of law could be both. So when it's criminal, then of course 63 gets attracted, but when it is civil, 63 doesn't get retracted, it stays where it is and we have to deal with it.
Yes.
So there is a declaration which is civil, arising out of original jurisdiction, the way we're looking at it, and is calling somebody a fraudster. Now the question is, how do we put a time frame on it? There's a decree standing in your face saying that you're a fraudster. Now what do we do with it? How do we treat that decree and think of it that it has a time bound or it doesn't? Because inter-party it probably stays forever.
Lord,
But for elections, should we take it differently?
Let's come to the time-bound question.
Yeah.
Time-bound question.
I will add to my lord, whether that time will be started from the date when decree was passed or from the day when the